New Mexico Real Estate Principles Workbook, page 34. 2. Indicating in what respects the applicant has failed to satisfy the board. 3. That the applicant may secure a hearing before the board by depositing in the mail within 20 days after service of the notice a certified return receipt requested letter addressed to the board and containing a request for a hearing. And 4. Calling the applicant's attention to his rights under section 61-1-8 NMSA 1978. C. In any board proceeding to take any action of type specified in subsection A, B, or C of section 61-1-3 NMSA 1978, the burden of satisfying the board of the applicant's qualifications shall be upon the applicant. D. When a board contemplates taking any action of type specified in subsections D through N of section 61-1-3 NMSA 1978, it shall serve upon the licensee a written notice containing a statement. 1. That the board has sufficient evidence that, if not rebutted or explained, will justify the board in taking the contemplated action. 2. Indicating that the general nature of the evidence. 3. That unless the licensee within 20 days after service of the notice deposits in the mail a certified return receipt requested letter addressed to the board and containing a request for a hearing, the board will take the contemplated action. And 4. Calling the licensee's attention to his rights as provided in section 61-1-8 NMSA 1978. E. If the licensee or applicant does not mail a request for a hearing within the time and in the manner required by this section, the board may take the action contemplated in the notice, and such action shall be final and not subject to judicial review. F. If the licensee or applicant does mail a request for a hearing as required by this section, the board shall, within 20 days of receipt of the request, notify the licensee or applicant of the time and place of hearing, the name of the person who shall conduct the hearing for the board, and the statutes and regulations authorizing the board to take the contemplated action. The hearing shall be held not more than 60 nor less than 15 days from the date of service of the notice of hearing. G. Licensees shall bear all costs of disciplinary proceedings unless they are excused by the board from paying all or part of the fees, or if they prevail at the hearing and an action specified in section 61-1-3 NMSA 1978 is not taken by the board. 61-1-13 Decision. A. After a hearing has been completed, the members of the board shall proceed to consider the case, and as soon as practicable shall render their decision, provided that the decision shall be rendered by a page 35 quorum of the board. In cases in which the hearing is conducted by a hearing officer, all members who were not present throughout the hearing shall familiarize themselves with the record, including the hearing officer's report, before participating in the decision. In cases in which the hearing is conducted by the board, all members who were not present throughout the hearing shall thoroughly familiarize themselves with the entire record, including all evidence taken at the hearing, before participating in the decision. B. A decision based on the hearing shall be made by a quorum of the board and signed by the person designated by the board within 60 days after the completion of the preparation of the record or submission of a hearing officer's report, whichever is later. In any case, the decision must be rendered and signed within 90 days after the hearing.